No, do not talk. Stop.
I said I won't say anything else.
Stop. Just stop.
That's how you treated me in October of 2024 as well.
I'm done. And here's what we're going to do. We're not sending it. She'll wait for the mail. I'll just adjourn this case out. Where are we adjourning it? Yep. We'll just put it out so she can get the mail. I'm going to do it that way. I was trying to expedite it for her, but she's going to treat me rudely. It's not going to happen that way. Rudely. Give me a date. I'm done. Mute her because I'm done with you. Let's state your appearances, please.
Troy Campaign, plaintiff, D squared.
Travis Gagne on behalf of defendant Ecolons.
All right, folks, where are we?
So this morning, I think we were scheduled for a settlement conference with Your Honor.
Yes.
I think originally we were aiming for a later time slot so we could spend some time with you to try to see if you could mediate something out.
Yes. How close are you guys? I mean, that's fine with me. I mean, I kind of set my schedule so that I have time for you guys. But
I agree with Mr. Young's statements. I will say, I don't know how close we are. We haven't exchanged emails. I know I owe you a response, but there was a lot sort of going back and forth. Not all of it is really in front of Your Honor, but
right.
I'm in agreement that we're here to at least talk about the case. I will say that if we don't get a resolution today, I think we would ask for a motion date because we believe a lot of this, if not all of it, can be resolved on the undisputed documents. But we're not at that point yet. I just wanted to let the court know that's where I would like to go if we can't resolve it.
All right. Very good. Then I've got, but I only had 5 today. I remember I set time aside for them. So why don't I pass it and then let me see what I can get through and then I'll get to you guys. Okay. In terms of meeting, would it be your preference to meet with the attorneys first, kind of clarify, figure out where you guys are and then figure it out?
If Mr. Gagne is agreeable, he and I could just sit and talk a little. I think we'll probably just kind of wind up repeating what we've already said, but we have no trouble talking to you.
Yeah.
I would say we do that and then we meet with Your Honor when you're available.
Okay. Real good.
But I have nothing against meeting with Your Honor, just attorneys, and then taking it however you want to do.
No, I knew you would have an objection to meeting with me, but that's okay. That's okay. I don't take it personal, Troika. I'm good. All right. Okay. All right. Thanks, guys. I'll pass it. Yasin versus Somerville.
The parties are out gnashing it out, but I think we'll begin in like 2 minutes out.
Okay. That works. What is
No.
She's not here.
I haven't seen her.
She's part of the attorney of record on this case, right?
Yes, representing the third defendant, Cambridge family.
She didn't try to sign it, did she?
No, and I do not have any communications today.
Hey. Let's see.
We're ready, Your Honor.
I passed it.
Oh.
You know, you're trying to rush. See, he gets these students, he's trying to rush me. Did you see that? Man, did you see it? No, new semester starts, he's trying to rush me. And, you know, I'm just trucking along doing what I do.
We have until April when the semester's over.
If the semester's over in April, is that right? Okay. Alec Jerome versus Eric Cassidy.
Your Honor, Andy Cooper is appearing on behalf of plaintiffs.
Your Honor, Travis Gagne again, on behalf of defendants Aaron and Paula Cassidy.
And nobody's here on behalf of Cambridge.
No, Your Honor.
Yeah. Okay, where are we? I know.
Your Honor, we are continuing to talk about ways to resolve this, and we were going to request an additional adjournment on the current motion.
Okay.
For removal.
I understand, Your Honor, that you have a busy schedule next week. So if we could get.
Do I? How do you know that? Oh, yes, I do. Yeah. Never mind. My bad. You are absolutely, I wasn't looking at the date. I appreciate you
so if we
keeping me apprised of that.
Trying to keep that day as clear as possible.
Yes, yes.
If we could do another 14 days, I think that kicks it out.
Well, March 3rd work for me?
March 3rd, I will be out of town, Your Honor.
Okay.
2 weeks from today, the 24th, is that not good?
I have March 3rd and March 17th. Yeah, I don't know if you wanted to go out that far. I mean, we'd find time for you if you don't want to go out that far, but.
I think it might be good to try to find time a little bit closer, if possible, not to go all the way out to the 17th.
There is March 10th. We can do March 10th. Is that too far out? If it's too far out,
It's not too far out, but I do it. So,
if I didn't have to schedule around attorneys, I'd have a perfect schedule.
Would you like me to go, would you like me to find a non-Tuesday?
Yeah, not Tuesday. After.
So we could do Monday, February 23rd at 11.
That works for me, Your Honor.
that works for me.
Was it? Okay. And I will adjourn this to Monday, February 23rd, 2026. What time are we?
11 a.m.
11 a.m.
And driver, before we get out of your hair, should be approachable.
Side. They're on the wrong side. Come on, council. Don't you know?
Sorry.
That's mine.
I know it's your fault, but I'm going to blame them.
Planes by the box. Oh,
That's right.
I correct myself.
All right. And on the plaintiff side, who do I have?
I'm sorry,
Your names?
Asim Yassin.
Heidi, Yasmin.
All right. Morning. Oh boy, here we go.
Good morning, Your Honor. I'm Justin Yu. This is my partner, Lazar Georgia. We asked this court permission to appear on behalf of our clients, Mr. Woodville and Mr. Jackson, under NCR 8.120 and under the supervision of David Santacroce
I don't know. Where are you from?
from Seattle.
Seattle. Did I already ask that of you? I may have. You've been before me before, right?
First time.
Yeah. Today's the first time?
Yes, sir.
Yeah. You're from Seattle?
Yes, Your Honor.
It's really damp there.
Yes.
Congratulations on your Seahawks.
I'm actually a Patriots fan, Your Honor.
You are?
Yeah.
I hate you.
Sorry, Your Honor.
Because I am not. The only reason I was rooting for the Seahawks, it was ABTP, anybody but the Patriots. I don't like the
Terrible answer, Mike.
what?
That was a terrible answer.
It was horrible. Horrible. Why are you a Patriots fan?
I was born in Boston, Your Honor.
Oh, well, that's a problem. Okay. So where'd you go to undergrad?
Tufts University in Boston, Your Honor.
In Boston, and then your family's in Seattle.
Yep.
So you came back to Boston and now you're at Michigan.
Yes, sir.
You just can't figure out where you want to be.
Right.
Okay. And what about you?
Yes, Your Honor. I'm from Chicago.
Yay, Midwestern.
Yes, sir.
I love it. Born and bred? Or
I was born in Bulgaria. I moved to Chicago when I was very young with my family.
Bulgaria? Where? Where'd you go to undergrad?
Went to Northwestern in Evanston.
Okay. I have a niece out in Chicago at Loyola, so
Very
I'll take it easy on you. So when it gets tough, turn it over to him because I like him better than you being a Patriots fan. All right. Thank you, gentlemen. Permission to practice is granted.
Thank you, Your Honor.
All right. And where are we on this case?
Your Honor, I was served yesterday after I saw the email at 8 o'clock at night where they have a counterclaim, so I would like to motion to get a continuance in order for me to be able
To answer the counterclaims?
Yes,
All right.
according to the statute, whatever the court deems
All right. How much time is it going to take for you to answer the counterclaims?
Well, to answer the counter between 21 and 28 days is what I would like in order to be able to get all the,
No, I probably won't give you quite all that time, but okay.
I'm sorry.
I probably won't give you that long.
Okay,
to
well,
file an answer.
The court deems appropriate, but you know, I will try to do my best.
All right. All right.
Carter, we agree to a month
because we have some additional discovery to conduct. We just received this case last week and we don't have all the
Students
documents.
are so cute. We'll agree to a month because we don't care about the court schedule. We just got to go to class. No, go ahead. I'm sorry. Don't mean
We
to
just
interrupt.
got this case last week, right? So we don't have all the documents yet, and we discussed with plaintiffs that we would ask for maybe a ledger or any communications or documents relating to any repairs that will be an issue in this case. And this will also give us time to file any FOIA requests to get inspection reports from the city, Your Honor.
So do you have a problem with the month adjournment?
No, Your Honor. That's cool.
Nobody cares about my docket. Nobody cares. No, I know. You're saying whatever. They don't do that. They come in just like demanding a month, but they get that from Santa Croce. Just demanding time. All right, let's do it this way. Do you have a ledger that you can provide them and repair records?
I will provide them with whatever I have, I will provide it to them. Yes, I do have a ledger.
Okay.
I have payment ledgers, I have, you know.
Okay, but what about documents regarding repairs to the
I would
premises?
have to look them up because there has never been any repairs except for one time, 2-3 years ago, when there was a little water problem and I had to pay a plumbing company to come and clean up the
line.
line. They did that, and after that, everything has been good. And besides that, repairs, changing of smoke detectors. It's been basically because it's
Okay.
still in construction and it doesn't need a lot of repairs.
Say within the next
I will
week?
provide them with everything that they asked me for.
Okay.
And I will also be asking them to provide for a lot of proof because they have a lot of allegations that are out of the air. I'm sorry if I'm talking too much wrong.
All right. No, that's okay. So, well, here's what this is the way the court works. Without necessarily issuing a formal order for discovery, I expect the parties to cooperate with each other regarding the information. So if you ask them for something, to the extent that they can provide it, if it's there, the obligation is there for you to provide that. Same applies to you.
Yes.
All right. Everybody's understood regarding that. All right. So what I will do then is I will indicate that you're to answer the counterclaims. In this case, you're to do that by February 24th. I'm going to give you 2 weeks to get an answer in on that.
Okay.
Okay.
Your Honor, one question, please.
Yes, sir.
I need them to provide their address because I heard that the address that they gave is not their address, but it's
You need to provide who?
the
Tenants?
the defendants to provide their correct address so that notifications can be made correct.
In terms of the,
Whatever address they want to provide to be notified to.
you mean in terms of your answer?
Yes,
Your answer should be sent to their attorneys. You shouldn't be sending things directly to the defendants.
so we do not need to have their address or anything on record.
Well, why do you need their address at this point?
Okay, the first thing that I was going to do was to send them, which I already probably provided them. They need to provide the address when they move 5 days after they move in order for us to be able to provide them with whatever.
Oh, 4 days, but yeah, go ahead.
And we haven't had that yet from them. So that would, I would, in case anything like that needs to happen. And, but otherwise I would just.
Well, hold on a second. At this point, you're seeking to provide them something.
No, I already did the last time.
Okay, hold it. I'm trying to figure out, why do you need their address right now?
Simply because the law says that I need to have.
They were supposed to supply to you a forwarding address within 4 days of the date of vacating the premises. And their failure to do so has its ramifications if that becomes something involved in this case.
Okay.
So you don't need it. any communication that you're going to have or make to the defendants in this case, you need to go through their attorneys.
No problem, Your Honor.
All right? So you're to answer by February 24th.
I will.
All right? And then I will adjourn this matter to March 10th, 2026, 9 a.m.
We have one more issue to raise.
Of course you do. Why? Because they're from Michigan. There's always going to be an issue. Go ahead.
Right before this hearing, that the property in question is owned by a corporation that plaintiffs own. They own the corporation, which then leases the property to plaintiffs, which plaintiffs then lease to our clients. And under law, they can't represent a corporation. So we're just unclear on the law specifically here. We just want to raise that to the court.
Well, who is the lease with?
The lease is with plaintiffs. They're just leased from their corporation.
So you're, well, why would they have to have an attorney and couldn't represent things? Because
They can't represent a corporation if they're not a licensed attorney.
but are they representing the corporation? You're indicating that the corporation leased to them. And
Right.
so,
But the corporation owns the property, so the prior order giving them possession of the property would be to the corporation.
why wouldn't I treat them the same as I would, that this really is a sublease? So
You're right.
if I treat it as a sublease, why would they have to get an attorney?
We don't have a clear answer on the law at this moment. We just wanted to raise, because it does add some complications or possible complications to this case, Your Honor.
Your Honor, if I may,
Yes, sir.
it seems like a perpetual, it's a wholly owned LLC. And in order to avoid having to retain counsel to represent that LLC, it's some sort of perpetual sublease to themselves individually. And then they lease it. Just, it seems clever at the very least. But I don't know, I mean, it obviates the rule that if you own a piece of property in a corporation and you benefit from owning a corporation, you have to hire an attorney.
Well, except that, I mean, you're right in terms of what you just stated about an LLC and the benefits that an LLC gets. The difficulty is in doing it this way, and the danger for them, well, maybe clever in doing it this way, is that any liability is going to attach to them personally. And so that may be a problem.
For tax purposes, LLC doesn't have its own tax return. It's part of the individual return. So the legal identity seems the same. I mean, look, they've been great, but we always prefer to have counsel on the other side. But we just I've never seen that before, so I just wanted.
I haven't either, and it's probably because the liability issues are probably potentially going to be substantial, and you're probably doing it this way. Frankly, they're going to lose the protection that the LLC has, but that may be their business. Yes, sir.
It's not an LLC, it's an incorporation. It's a C corporation. I live
Okay.
in the apartment where the lady lived, where she.
Yeah, but sir, here's what the,
Myself.
okay, you talk over.
I'm sorry.
Go for it.
I'm sorry.
Here's what the issue is, and I don't know that I'm going to necessarily address it today. They've raised it as a potential, is that it doesn't matter what type of corporate entity owns the premises. That corporation has leased to you.
Yes.
Okay. I think you need to understand that should they prevail on some issues, the liability or some of this goes directly to you. The corporation is not a protection from it. There may also be issues, and maybe this is what they're getting at. There may also be issues of if it is a circumstance where the corporation isn't really there, that it's just there in name, but you guys are operating, then they're going to go behind that corporation if they needed to get at the property. So,
I understand that.
okay.
Corporations, legal, everything is up to date. And it's,
Yeah, but so let me put it this way, and I'm not saying that it is, but if it were a situation that the corporate entity is really nothing more than a sham, that can create other problems for you.
I understand, Your Honor.
Well, I hope you do. I don't know if we'll get there. Pardon?
It's an interpreting corporation which owns the premises, and it works with the courts. I provide interpretation for the court. I'm a qualified interpreter. So the corporation is good, Your Honor. So I have no qualms.
Well, it may be for some purposes and maybe not for others. Yeah, I'm going to suggest to you, sir, this having been raised, because I don't think you understand what I'm saying. I'm being very careful in what I say, that you may want to get some legal advice, because I can see where it may potentially cause some problems. Anything else?
That's it, Your Honor.
You sure?
Yeah.
You sure, Seattle?
Yes, sir, Your Honor.
He's a patriot, man. He's a patriot. You know what? I should take him. I should have you take him in. You see? Yeah, no. He didn't know what to do. He's like, oh my God.
One more question, Your Honor.
Yes.
You gave me 14 days, but if you give me 21, since they are asking for a month, that way I can have a little more time to provide them with whatever they are asking me to get.
I need an answer by then. I'm not saying that I need all of the documents.
Oh, okay, I'm
I
asking
mean,
the purpose to, if anything comes up, I can add it to the answer. Is that correct, Your Honor?
I'm not going to say it that way. You need to answer their counterclaims by that point. The providing of documents and other information between the parties is something that is going to continue throughout. So you get the 2 weeks. You can provide an answer to this in 2 weeks. I'll see you guys in 30 days.
Okay, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you.
Have it write it in Bulgarian. Just- What? Just see if he can, because I don't know if he's telling me the truth. I just don't know. Just saying.
I'm impressed. I didn't realize you read Bulgarian.
I do. I'm fluent. Yeah.
So much.
That's easy. Thank you, guys. Take care. What is this last one?
Requires a major interpreter.
Requires a what?
Major.
No, it doesn't.
It is present, but I don't believe tenants are.
What is this on for?
They are not paying.
Okay, he's gonna. Sanford versus Normal.
The judge pauses and starts breaking it down carefully. Why would they need an attorney? He asks. An attorney can't represent a corporation unless they're licensed. But are they actually representing the corporation? The court looks at the lease structure. The corporation owns the property, but possession was given through what looks more like a sublease. If it's treated that way, the question becomes simple. Why should they be treated differently at all? The judge weighs the logic, not the labels, focusing on fairness and substance over technicalities. So here's the question. Should courts focus on form or on what's really happening? Like if clarity matters, share if this helped you understand the issue.
Good morning.
Gil Stanford.
All right. Ms. Norman, can you state your name?
Susie Norman.
Okay. And that's a wrong screen. No, it's okay. I'm good. I'm good. All right. Where are we on this case, folks?
At the last hearing, we were reading on the evidences I sent. One was a flash drive.
Yes.
Due to the weather and the courts being closed, it hadn't been logged yet.
Correct. I think
Also,
we have it now.
Yes. And I believe that your coordinator helped Mr. Stanford to play his flash drive.
Right. Did you get all the stuff off of the flash drive?
I did see the video of the previous hearing on that, yes.
Okay. And so with reference to that previous hearing, you have something you're holding up. What are you trying to do?
I submitted to the court an answer to that, and I sent a copy to her. I don't know if she's received it or not yet.
Is that the response to defendant's objections and evidence submitted about January 15, 2024 hearing? That's what you, okay.
That's right.
All right. Have you received that?
I have not.
Okay, folks. All right. All right. Somewhere along the line, we've got to make sure, because it becomes impossible for me to conduct a hearing where one party has submitted something and the other party doesn't have it. And I'm not saying, I'm not blaming either party. I'm just saying that's the cold-hearted reality of where I end up.
Your Honor, may I say something?
How did you send this to Ms. Norman?
U.S. mail.
Okay, well,
You know, and
that's going to be.
I thought our hearing was a little later in the month. I thought she was going to get it. And I just got the notice about our hearing date yesterday. So I was thinking maybe I should.
Well, that maybe should tell you something about the mail. All right. Here's what I'm going to do. I think we have Ms. Norman's email, right?
Yes, sir.
Okay. So,
Judge
folks, they're
Simpson,
not sure that. Yes,
can I
ma'am.
say something, please?
Yes, go ahead.
That video from the hearing from 10/22 of 2024 has on there where Mr. Stanford waived his right to monetary damage and rent because of the case, and my case being I dismissed my case in order to come to that end. So I don't know. I just feel like at this point, it's, we're just on the court's time and we're wasting it with,
Well,
all of these things.
Ms.
It's just-
Norman, I understand what your position may be. My position is that if somebody submits something to the court, I have to at least look at it and consider it. The very fact, I don't think, if you think about the last hearing, you submitted something and I didn't get it because of whatever the circumstances were. I didn't have it. I don't think you would want me to proceed without having that. Mr. Stanford has submitted something. I'm not going to have a problem going through it. You just have to have it so that you can respond to it if necessary, because you're entitled to have it. Here's what I'm going to do. At this point, there'll be no additional filings. all right? Because I don't want to end up in this circumstance. We have Miss Norman's email.
Yes, sir.
All right. So what I'm going to do to expedite the process, Miss Norman, because normally I put it out however long it may take the mail to get there. I'm going to have my staff copy what Mr. Stanford has submitted, email it to you so that you have it. Okay?
So,
And then
so what
my
happens
next-
then? He's got an answer to the video, and then I see something on his answer, but yet I can't
then
answer.
you guys can argue that before me. Miss Norman, I can't force this to go any different.
I don't
If
want to
I could-
argue. I want it to end. I want it to end. And this is just how we were in October of 2024. Frustrating you.
So I am not frustrated. I'm frustrated by your failure to
I'm not a failure.
permit the court to
I'm not a
proceed
failure.
with how it has to proceed. I just explained to you why I can't do it the way you want me to do it.
Because he submitted an answer. Is that correct?
What did I just tell you, Miss Norman? What did I just tell you?
Sir, I've been in this courtroom almost probably 13 times now. It's very frustrating for me. I'm not a failure. I'm doing everything that I can to end this court case. He has.
Norman, I'm going to tell you this, and then I'm not hearing anything else from you. I'm going to do what I got to do.
That's fine.
I'm just
That's
going to,
fine.
no, do not talk. Stop.
I said I won't say anything else.
Stop. Just stop.
That's how you treated me in October of 2024 as well.
I'm done. Then here's what we're going to do. We're not sending it. She'll wait for the mail. I'll just adjourn this case out. Where are we adjourning it? Yep. We'll just put it out so she can get the mail. I'm going to do it that way. I was trying to expedite it for her, but she's going to treat me rudely. It's not going to happen that way. Give me a date. I'm done. Mute her because I'm done with you.
March 10th.
March 10th. I'm adjourning this to March 10th.
The judge reviews the record calmly. Evidence was submitted. A flash drive. Weather delays kept it from being logged, but now it's been reviewed. The video was seen. The court waits for anything further. Silence. Then the tone shifts. Do not talk. Stop, the judge says firmly. The frustration is clear. This isn't the first time. The judge decides to move on, adjourning the case so materials can be sent by mail instead. What could have been expedited isn't. The ruling is final. So here's the question. Should courtroom respect matter more than speed? Like if professionalism matters, share if court process should stay controlled.